Recent appreciation of the Kenya shilling, which they expect to be sustained. Expectations that the subsidized fertilizer initiative would continue and that the March-May 2024 long-range season would be favorable.
At page 106, what is the date of this report by CBK?
March 2024.
And on the motion before the Assembly, rather before the committee, what is the date of the motion?
Let us check actually.
On what date was the notice of the motion before us given?
24th April.
24th April.
Yes.
So, it will follow, therefore, that this CBK report is much older than the motion before us.
Correct.
It must also, therefore, follow that this CBK report cannot have been authored with this motion in mind.
It cannot.
Let's go to page 115.
Okay. Several farmers indicated that proper timing in issuance of subsidized fertilizer and the quality of fertilizer assessed were important factors that support increased acreage.
So again, without trivializing the misfortunes some farmers suffered, is this a positive or negative story? What you just read?
Yes.
Is it positive or negative?
It is positive.
Good.
117.
Let's go to page 117. Again, can you read the highlighted part, sir?
Access to government subsidized fertilizer. The proportion of respondents who reported to have accessed government subsidized fertilizer increased substantially to 67% in March 2024 from 53% in January 2024 survey.
An increase of 67%.
Yeah.
Would that depict you as a successful cabinet secretary or the rogue cabinet secretary? The move of the motion would want the world to believe.
From my judgment, he is a successful cabinet secretary.
Actually, a very successful cabinet secretary.
I was being modest.
Let's go to 121, page 121 of this document. Again, what does the Central Bank of the Republic of Kenya say?
Approximately 70% of sampled farmers reported to have benefited from the subsidized fertilizer, a key input in crop production.
So again, does that depict you, sir, as the clown the media spent for South again?
I was ranked quite highly, and I think the audit reports can really demonstrate that. And at no single time did I attract any audit query. At no single time did I not absorb my budget within the year.
Let's go to page 131. What is this document and why have you placed it before the committee?
This is just to prove or to demonstrate to the committee that I've been a victim of an organized campaign by the media and other financiers to malign my name, and this is the story I made reference to that was carried by the Star newspaper purporting that I'd been arrested together with my deputy, with my permanent secretary.
When did this happen, Honorable Linturi?
This is story. The exact date. This is last week. It's the same last week, Thursday or Friday thereabout.
It says in the caption there, DPP orders arrest of agriculture Cs.Linturi, PS Porono of alleged fake fertilizer saga.
Yes.
To the best of your knowledge, has the DPP ever ordered your arrest or that of your peers?
No.
Has the Star ever apologized to you or to the peers for this fake news?
They have never, and at no time that we ever written a positive story about me.
Again, is the Star one of the big newspapers in this republic?
Yes, it is.
Let's go to the document at page 132. What is that document, sir?
This is a decision of the Supreme Court of Kenya on the Mike Mbuvi Sonko case.
Yes. Now, I want you to take the committee to page 189 of the paragraph 149 of that decision.
Page 189, paragraph
149.
Do I continue?
Please read paragraph 149.
As to the standard of proof in impeachment charges, the Court of Appeal, in its judgment in Martin Nyaga Wambora and 3 others versus the Speaker of the Senate and 6 others, Civil Appeal number 21 of 2014, found that to impeach a governor requires a high threshold, but that standard is neither beyond reasonable doubt nor on a balance of probability. Noting that the threshold for removal of a governor involves gross violation of the Constitution, we hold that the standard of proof required for removal of governor is above a balance of probability, but below reasonable doubt.
To the best of your knowledge, sir, would this standard of proof be met when all the witnesses said they are not even aware what you are accused of?
It will not be met.
Would it be met when the mover added cross-examination instead of pointing to the alleged approval, kept debating the motion?
It will not be met.
Okay, let's go to page 190. Next page.
Injunction by senior counsel.
Yes, I will restrain myself deliberately from objecting to anything. Partly because when I do object, you say to me that, look, wait until your time for cross-examination.
Do we stop the clock, Honorable Chair?
Now, we have a witness.
Counsel, senior counsel. Counsel, I confirmed to you that our team is
Yes,
on
the witness being asked about surrender of proof. Should he really be asked? Is that not something my learned friend can comment on when he's making submissions?
Honorable Chair, again, I seek your protection. I have a job to do, and there is no rule I have breached. So let me just be allowed without interjection, because I keep saying, you know, the Honorable Camino is almost my grandfather, and I've really resisted having to have an altercation, because in Meru, where I come from, you don't have an altercation with your seniors, whether they are right or they are wrong. That's the rule in Meru. They are your seniors, they are your elders, but also elders have to also exercise restraint of some sort.
But Chair,
Counsel.
Presiding Chair.
Honorable TJ.
I think that is the precise reason why you should accept wisdom from your grandfather on issues of law.
He is not just my grandfather, he's a partisan player, because he has a client he's representing, and I represent the adversary. If it were just an exchange between a grandfather and grandson, on this one, he is a partisan counsel, just like I'm partisan counsel, and that's why I'm saying, why can't I just be allowed
but
to do
just
my
listen
job?
to me. The wisdom from the patriarch is that you need not cross-examine or lead evidence on opinion on law, because your client that is not here to lead evidence on value judgment on law. We will see them in submissions. You will make submissions on them. And whereas it is very appropriate for you to bring them to our attention, we also want to save time. And so things which will come before us as submissions and judgments which we can make decisions on, you probably can save time. I think that's
Fair
the wisdom.
enough, Chair.
That's
Like
the
I
wisdom
always say,
from the old man.
Today I'm not in any quarrelsome mood, and like I've told you,
1 minute.
I also always usually agree with my senior on the other side, so let's move on.
Chair, if you allow me, yesterday, not anyone else other than the Vice Chair did mention that this matter is more of a political process. And being or having been in politics for some time, I'm being tried in the public court. And there is also need, and that is why these proceedings are not in camera, for me to also get an opportunity when an opportunity arises to respond to the story that the public has been given. And it is true, whatever happened here yesterday was clearly playing to the gallery. Without that opportunity to explain to the public, I think prejudices me when it comes to issues of how we relate with my colleagues out there, with the public out there, because of us and protect.
Council, proceed.
Honorable Linturi, let's go to the document number 10 at page 252 of your budget. Please, can you explain to the Honorable Select Committee what this document is and why you have placed it before the committee?
This is a letter addressed to me by the DCI in regard to a number of complaints that they were investigating. Reference was made in the motion in regard to my imminent arrest by DCI, and this matter or this letter explains that the cases that were being referred to are cases that were investigated by the DCI. The referral was forwarded to the DPP, and the DPP directed that the files be closed and with no further action. And if, for whatever worth it is, one of these cases, I was the complainant, and in that Justice Ongundi judgment, if you go through it, one and how ended up being the victim. I was the complainant, I was the victim, but at the end of the day, I was one to be charged, so that you understand what kind of games were there at that time.
So, Honorable Linturi, we have a motion before this committee that says there are serious reasons for believing you have committed a crime, and we have a letter from DCI confirming that those matters were closed. What is your comment?
You know, that allegations should fall flat because we have demonstrated to the committee that he did what was said in the motion is not correct.
Let's go to the document number 11. What is that document? And why have you placed it before this honorable committee?
This is a judgment of the court in my favor.
Can you read for us at page 261, the highlighted part?
I think this is what Justice Manjanja said, that the first defendant's claim, the first defendant's counterclaim is allowed on terms that the judgment is entered for the first defendant against the plaintiff, second, third, and fourth defendants jointly and severally for the sum of 21,846,607 with interest at the court rates from the date of filing suit until payment in full. I am the first defendant in this matter.
So, Honorable Linturi, this judgment relates to one of the alleged acts of forgery and whatnot against you. And the judge ruled in your favor and even awarded you 21 million shillings. Did the media publicize this victory on your part the way they have been publicizing the allegations against you?
They've never.
Good. Let's go to the document at page 263. Why have you placed it before this committee?
This is also a ruling in my favor on a matter that revolves the occupation and ownership of my house in Runda.
Again, Honorable Linturi, 5 years of negative media publicity about that house. The court has ruled in your favor. Did the media publicize this victory on your part?
They can't.
So the public is still stuck with the image that there was a claim about your house, but they are never told the other side when you win.
They are happy to do that. When we win, we have no access to publicity, and if there has to be there, then you must pay for it.
Let's go to page 278. What is that document?
This is also another. There's a judge. There's an order from the Court of Appeal.
How many judges of the Court of Appeal have made that order?
There are three.
Three judges of the Court of Appeal issued an order in your favor.
Yes.
Did the media publicize this victory?
They did not.
So again, the public is left with the image of Linturi, the bad guy. Never mind, the Court of Appeal has vindicated him.
Yes.
Let's go to the document at page 287. What is it and why have you placed it here?
This is also another judgment.
From which court?
From the Chief Magistrate's Court in Nairobi, and the judgment relates to the much publicized divorce that never was, and again the magistrate ruled in my favor, and the same was never told to the public.
So again, the magistrate has ruled in your favor. The picture painted to the world for 5 years is of a rogue Linturi.
Yes, and I wish today they are televising live, because this is the opportunity probably I may have.
Let's go to page 306. What is that document?
The issue we have here is of fake fertilizer. We are spending a lot of time on love matters. We are spending a lot of time on media. Can you give some guidance really of how?
Honorable Chair, let them withdraw ground number 2. Our work will be very easy. They can have it both ways.
Chair.
Thank
Chair.
you. Honorable Malulu.
Yeah. I would like you to restrain our senior counsel because they're the ones who raised these issues. You can see even the client is pleading that he should also have time for this to be clarified because yesterday when they were prosecuting this, it was also on the media, live. So when it comes to him now responding, why does he want him not to respond?
You have
probably
made your point,
declare-
Honorable Member. Honorable Jane, then
Chair.
Honorable Manyo.
Thank you, Chair. Chair, I think it is very unfortunate that the presenter of the motion or the mover of the motion invited us to listen to this kind of information. And you see, it is common knowledge that the issue at hand is the issue of fake fertilizer and the nexus between the fake fertilizer and the CS. But unfortunately, we were presented with a motion that is laced with information on past love affairs and other matters. And as unfortunate as it is, we were invited to that information, and unfortunately the parties have to deal with it.
Thank you, Honorable Manyo.
Thank you, Madam Chair. Although we are listening to the CS side, the person being mentioned is not here to defend herself. That's why we are finding it difficult. We cannot listen to one side of the spectrum, and the other side of the spectrum is nowhere. So if we must dwell on this matter, and it's very important, then let Lady Honorable Mary Ann, the ex of the CS, come to defend herself. Otherwise, we are just listening to rhetorics.
Thank you, Honorable Omanyo. You have made your point. Honorable.
Thank you. Thank you very much, Madam Chairperson. And unfortunately, what we are dealing with, as far as this testimony is concerned, are court cases. Those court cases were introduced by the mover of the motion. So surely the respondent has every right to comment on each of those cases. When the mover introduced the cases, sorry about that. Hey, don't say that.
This is a serious matter.
Sorry,
Bedroom affairs.
this is very serious.
This is bedroom affairs.
All right, I think the mic is loud enough and you don't have to see me anyway. Honorable Chairperson, the mover of the motion introduced the cases, and the comments we are getting are in respect of each of the cases cited in the motion. So two things we have to say. Number one, the respondent surely has a right to respond to the cases that were put before us. That is number one. Number two, it is very important also to recast that where a witness is actually a lawyer or an advocate, issues of law and opinion can actually be put to him, because that is what our rules provide. So I do not think the council is going out of the way to try and get these cases recited and commented on, because they are part and parcel of the facts in issue before us.
Honorable Yusuf.
Madam Chair, I'm not a lawyer, and I can't argue on the point of law. But if my mind serves me very well, yesterday we restrained Honorable Wamboga not to comment about this issue. It was a debate in this committee. I never wanted to argue about this issue. We want the honorable members, yes, and his lawyer to restrain themselves on this issue. The way we have reprimanded yesterday, Honorable Wamboka to restrain himself. Thank you.
Chair.
Thank you. Honorable Tandaza.
Thank you, Chair. I think the process was very clear that the mover actually prosecuted his case based on what he had presented before this committee and before Parliament. And the Mheshimiwa, the CS, also put his replying affidavit in the same manner that he is holding and is being questioned or is being led through by his counsel. So I don't see anything wrong. For as long as the counsel is taking him through his affidavits, which were filed and we have them, then he should rightly proceed, unless he is asking questions beyond what is in those replying affidavits. Thank you, Chair.
I think members have made their points. Honorable Omanyo, you have severally pleaded with us that we invite Marianne, that we will deal with it at our own level later, so that as a select committee, then we can give you our response. The other thing is about the proceedings. Yesterday, we did not stop the mover from presenting his case. And at one stage, the council here proposed that he withdraws so that we don't, deliberate on this. I know some of us are real Africans, and discussing bedroom matters is not very pleasing. But we have been put in this situation by the mover and his counsel. Now that they did not withdrew yesterday, we have no option but we have to wrestle with all this. And ours is just to say we do not want to get into the details, but for every case that has been presented, they are at liberty to respond, so that just as we publicly heard the mover yesterday, they can also respond and the public can also hear their side. I don't know why we are being affected, because if we were not affected yesterday when we heard all this news, we shouldn't be affected today when it is the second day and we are even used to now the things that are happening. So I suggest that we proceed for the next 20 minutes. At 1, we will break for lunch, and then we will come back. Thank you.
Much obliged, Chair. So, Honorable Linturi, the document at page 306, why have you placed it before this committee?
Your Chair and the committee, I've placed this document before the committee to demonstrate to the committee, contrary to the assertion by the mover, specifically under this civil suit number E138 of 2018, I got favorable judgments from the rulings from the court.
So there is a favorable ruling from the court on the matters in ground 2 again in your favor.
Correct.
Was this favorable ruling on your part ever publicized, like the accusations against you had been?
It was not, and I don't think it will ever be.
It will never be. Let's go to the document at page 314. Why have you placed it before this honorable committee?
It's also to demonstrate the same thing.
Again, the court vindicated you. Was this publicized? Did it headline news?
It was not.
It was not reported.
Yeah.
Let's go to the document at page 319. What is it and why have you placed it before the committee? I hope you note, Honorable Chair, I'm desisting from going into the details because I don't want us to.
This is also another court order which was in my favor and which also was directing the police to give security to evict the member from my house.
Was this decision in your favor given the publicity that for 5 years the world kept being told about the bad Linturi?
It was not.
It was not publicized. And why have you placed the document at page 320 before the committee?
It is also another document to prove to the committee, despite her losing those cases, she went for appeal, and the appeal was also dismissed by the court.
So she lost, she appealed, but she still lost.
Yes.
Was that victory on your part, given the publicity, to erase the image the world has been fed for years and years of Linturi the bad guy?
It was never done, contrary to what had been published before, as a man who depends on a woman for livelihood, who is kept.
Do you actually depend on women for livelihood, Honorable Linturi?
I maintain them.
Let's go to the document at page 337, sir.
Yes, 337.
Why have you placed this document before the Honorable Select Committee?
Your Honor, is also to demonstrate that despite the appeal that she made, the court also ruled again in my favor.
So when the court ruled in your favor, was this victory on your part ever publicized the way the allegations against you have been publicized for 5 years?
It was not. And members of the committee, not only did I get these federal court orders, but I also got the costs which I have never asked for. I think it's important.
So, Honorable Linturi, we have gone through decision after decision after decision, through and through and through, and they are all in your favor. Correct or incorrect?
Correct.
Are these decisions made by one judge?
No.
Are they decisions made by one magistrate?
No.
Are they decisions made by one court?
No.
Are they decisions made by some clique of judges and magistrates?
No, no.
As a matter of fact, are these decisions from the same court station?
No.
So you will agree that these are well-spread decisions from various judges, various courts, various magistrates.
Yes.
Let's go to the document at page 361.
361?
Yes. Why have you placed this document before the Honorable Committee, sir?
I have placed this document before the committee to demonstrate that the alleged contract that gives leeway or room for Africa, Western Capital African Datomite, to use the NSPMB infrastructure to display his GPC and diatomaceous material was signed or executed long before I assumed the office of Cabinet Secretary.
What is the date given on the face of the document?
The 1st March 2022.
Were you the cabinet secretary
I was not.
on that date?
No.
To the best of your knowledge, sir, can you be dismissed from office for agreement signed before you took up that office?
If that was to happen, it would be very unfair. And by the way, even the current administration had not come to office. It's not only Cs.Linturi as CS. Even the current administration.
So the entire
was not
Kenya
there.
Kwanza administration had not even come to office?
Yes.
You are accused, sir, through this document of lying that this agreement was for a soil conditioner and not fertilizer. Does the word fertilizer appear anywhere in this agreement?
I've not seen any at all, and it doesn't.
How many pages does this document have?
I think 5?
5
No,
pages.
no,
and
6.
Six.
And then here for
And
7.
across all of them, the word fertilizer or its equivalent doesn't appear anywhere.
Yes.
What do you make then of the accusation against you that you lied to the departmental committee that this was an agreement for a soil conditioner?
I think it's the mover who is trying to mislead the committee and not me. Who is either?
It's the mover who is trying to mislead the committee, not you. Let's go to page 367. L together with 368. Why have you placed those documents before the committee?
I have this document before the committee to demonstrate that if I really want the NSPB Chief Executive Officer to exercise caution in the receipt of fertilizer, because I really wanted them to make sure that whoever had won that contract, because I got to know about it when it was over, that all the suppliers were able to file with the institution the fertilizer chemical composition of what they had won in that particular tender, so that we will be able to really to confirm before delivery that farmers will get the right fertilizer to suit their planting requirements.
Please read to the committee the parts that are highlighted in that letter.
There is therefore need to ascertain the quality and composition of fertilizers before delivery to ensure that farmers get the right fertilizer to suit their planting requirements and boost agricultural productivity. And therefore, the purpose of this letter is to ask the suppliers to confirm in writing the fertilizer chemical composition they will supply before delivery. This was a
What is the
provision
date of this letter, sir?
20th in December 2023.
That was long before the problem the committee is now seized with, isn't it?
Yes.
Is the content of that letter consistent with the allegation of a fraudulent minister who is approving the procurement of fake fertilizer?
It is not consistent.
Is it consistent with the narrative of an incompetent minister who has no clue what is happening in the ministry they have?
It is not.
Is it consistent with the allegation as to the existence of a policy to procure fake fertilizer?
It is inconsistent.
It is inconsistent.
Yeah.
Let's go to 369. You noting the guidance already given by the committee. Why have you placed that document before the committee?
Just like I said, this is what the gossip within the Star newspaper that spreads out stories trying to say that within sources close to power and intimated that one of the members from the Rift Valley and choreographed the fake fertilizer to have and if Irene, her ex-boyfriend, CS fired.
Let's go to the document at 371. Why have you placed, what is it, and why have you placed it before this committee?
371. Then 371 is the Evidence Act,
Yes.
which guides procedure on collection of evidence.
And what is your understanding of the highlighted part?
All evidence must be direct. All evidence must, in all cases, be direct evidence. Wherein, and the purposes of that, subsection 1, direct evidence means with reference to a fact which could be seen, the evidence of a witness who says he saw it. With the reference to a fact which could be heard, the evidence of a witness who says he heard it. And the reference to a fact which could be perceived by any other sense or any other manner, the evidence of a witness who says he perceived it by that sense or in that manner.
So this provision of the law, sir, says any accusation against you must be proved by a witness who saw it with their eyes, who heard it with their ears, who touched it with their fingers, or perceived it with any of the other 5 senses. Have you seen any such witness in the proceedings against you?
I have not.
How about the document at page 373? Why have you placed it before the committee?
This is a case by the House of Lords of England on, and is on an appeal from the Supreme Court, and it was on, I think, on hearsay evidence, which the court held that the ones spoken by the woman did not form part of the registered tie and were not therefore accepted from the fundamental rule against.
You say this is a decision of the House of Lords and you're a lawyer. What type of court is this called the House of Lords?
This is the highest court in England, I think.
It is the highest court in England and Wales. Is it a respected court?
It is.
Is our legal system based on the legal system
Yes,
of England and Wales?
yes. You remember we are in British colony.
As a matter of fact, Honorable Linturi, is this decision the highest possible judicial opinion you can get on Section 63, which you've just read about direct evidence?
Yes.
Lastly, can you read from that decision at page 379 what the House of Lords held?
This is what the House of Lords are to say. The rule against the admission of hearsay evidence is fundamental. It is not the best evidence, and it is not delivered on oath. The truthfulness and accuracy of the person whose words are spoken to by another witness cannot be tested by cross-examination, and the light which his demeanor would draw on his testimony is lost.
Honorable Chair, I suggest we could leave for lunch at this point. Then when we resume, my learned friend, Mr. Boniface Mawira, will take the remaining part of the examination in chief.
Thank you. We will do exactly that, but I will release all the other parties apart from the select committee so that we can consult for 2 minutes.
next to me.